Hello, thank you for joining us. My name is David Siegel. You've tuned in to Legal Action. My co-host Jesse Variantes is once again with us, and we are honored to have the Honorable Judge Brian Diamond from the DuPage County Courthouse. Is that correct?
Yes, thank you very much for inviting me.
You're welcome. Today we're going to be talking about orders of protection and all the items that are related to that topic. We have someone who is knowledgeable in the area as well, Jesse Variantes, and of course the judge who presides over those types of cases. So Judge, welcome. Tell us a little bit about yourself and what you do.
Well, I've been a judge for about 2.5 years. I am presiding in courtroom 2002 at the DuPage County Courthouse, and I hear bond hearings, and I also hear orders of protection during the week. So that entails essentially people who come in, mostly women. It's about a 7-to-1 ratio of women to men. However, and I'll probably refer to women simply because they're the overwhelming majority at this juncture. And the procedure was founded through the domestic violence statute, and it was designed to provide protection for victims of abuse. So that's the court basically stands in the role of hearing these cases. A petition comes in. I, as the judge, will read the petition, examine the petitioner under oath to determine the facts which warrant that petitioner coming in and seeking the protection of the court. Then I would enter an order if I find that there is an order of protection warranted. I enter an order which provides a number of different remedies for that victim of abuse, the primary one being, and the one most often granted, to keep the victim away from the abuser. And there are other remedies that are also involved. Very often it involves giving the victim the exclusive possession of whatever the residence is. So if you have someone, for instance, who is in an apartment and they're living in the apartment with the individual who is abusing them, and they come in with their petition, and they can convince the court that they qualify under the terms of the Illinois Domestic Violence Act for an order of protection, and that the balance of the hardships in that case suggests that that victim should remain in the house and that the abuser should be kicked out, then the order is entered to that effect.
Now, many of these people are coming before you without counsel. Is that correct?
That's correct. The vast majority do come in without counsel. However, they are also accompanied by advocates. There is a system set up under the Illinois Domestic Violence Act through the Family Shelter Service for advocates that are not involved with criminal activity as such, and a parallel system through the state's attorney's office for those individuals who are the subject of domestic violence, which actually constitutes a crime and has been charged as a crime. So they are assisted by advocates.
Jesse, what's your experience with clients who call you before they obviously get before the judge in terms of what they're experiencing, what kind of anxiety they have, and ultimately what is the goal that they're trying to accomplish when it comes to seeking an order of protection?
Well, actually, I've been on either side of it. I've defended orders of protection and also have prosecuted them. And a lot of times, I mean, you know, there's a real abuse. Someone has struck them. It's usually the spouse, and you know, they're afraid and they're terrified, and usually too they're afraid for their children. Sometimes what will happen is the other spouse will tell them, you know, or threaten to take the kids away and remove them out of the jurisdiction, and that's where a lot of the things that I've seen have come up too.
Judge, what are some of the grounds or basis for actually granting that order of protection? Because I do receive a lot of calls where I don't hear an imminent threat.
Well, actually, as Jesse indicated, one of the grounds is that there's a threat to remove the children. And I think the genesis of the Illinois Domestic Violence Act was the fact that the legislature and the communities, the policing agencies, and the prosecutor's offices recognized that violence was one of the leading causes of injury to women in our society. That caused the legislature to take a look at it and say, you know, these abusive situations need special attention, so we have to set up a system to protect these women. One of the phenomenon of domestic violence is that the women, and again, I'm using the term women, but there are men as well, but the women who are abused do not leave these relationships. It's for a variety of reasons. Sometimes it's a self-esteem problem. Sometimes it's the fact that this individual who's abusing them is their only source of financial support. Very often the abuser has put them in a situation where the abuser has isolated them. So they have no friends, they have no social contacts, and that causes fear. They are afraid for their children. They aren't aware that there's another place to go. There actually are shelters out there, but they don't feel that they have, maybe they don't know about those, or they don't know that they're available. They might not have friends or family. Oftentimes we have individuals who are immigrants to this country who don't know anybody in the country or the language, so that presents a barrier for them to come in. So the grounds typically are what you might expect in terms of violence, you know, someone physically assaulting the victim. The grounds also can consist of stalking. We often have cases where, for instance, a boyfriend and girlfriend situation where the girl has told the boy, I don't want to see you anymore, and he can't accept that. So he stalks her, he chases her in her car, he text messages her, he leaves voicemail messages, he confronts the new boyfriend or the new individual in the picture in her life, and he won't leave her alone. Sometimes this extends to family members where the boyfriend is confronting the parents and they're trying to protect their daughter. So all of these situations can lead to the request for an order of protection. There are also cases where there's no physical confrontation. It may be telephone harassment. It may be people approaching a former girlfriend at work or trying to get him or her fired from their job. So there are a number of situations that can formulate the grounds of what I will call a typical request for an order of protection.
Let me ask you, against whom can you file an order of protection?
You can file an order of protection against, there are actually three different categories. The first one is someone with whom you are involved in a relationship. And by relationship, it can be a boyfriend and girlfriend, it can be a spouse, it can be an ex-spouse, it can be someone connected through a spouse, so in other words, an in-law or an other relative, someone else related by blood. And oftentimes in this day and age, we have people who aren't married, who have children out of wedlock, but they live together, so they're anyone living in the same household. And so that's another relationship. So if you have boyfriends and girlfriends who live together, or even if you have people who are just tenants in the same household, and there's some abusive relationship that develops out of that. Also, the orders of protection can be requested for individuals who cannot bring them on their own. For instance, a disabled or elderly parent or individual, could be a neighbor that you see being abused, that sort of a thing. Those individuals can also come in, and the orders can protect not only the individual, but also the caregiver for that individual as well. So,
Judge, if we can touch a little bit upon the time frame when someone actually comes before you and you grant an emergency ex parte order of protection. The person walks out of your courtroom with an order of protection, but the person that they're seeking the protection from doesn't yet know about it. Is that correct?
That's right.
So how does this all work? How does the protection actually kick in?
Well, what happens is if the order of protection is granted, and I'm glad you raised the issue of ex parte, what that means is the abused individual can come in and ask for the order, and they don't have to tell the person who is abusing them. So many times these relationships, obviously, if you told the abuser, he would try to stop the person from coming in and getting that order. But the order, once it is entered, then usually the advocate is assisting, and they will, the process from there is that the order is served by the sheriff's department.
How quickly, Judge? That's important.
It has to be done. Normally the orders in my court, they have to be set within 14 to 21 days, because this is an ex parte order, which is something that's unusual in our system, where normally both sides are advised before any rights are taken away or affected. This is an unusual circumstance, so the law requires that be for the shortest possible time. It's between 14 and 21 days. So I would set the hearing 14 or 21 days out at 9 o'clock on my call. The victim would be told You must come back here at 9 o'clock on that morning if you wish to extend this order. Otherwise, it will expire at noon on that day. And so then the order is turned over to the sheriff's department. She's given a copy, and she's told that if once the abuser is served with the order, that person has to, typically there's a stay away order, that person has to stay away. The sheriff, if the abuser is at the home, will go to the home, serve it on the abuser, and tell him to get his things together, and he has to leave the home. And then she's allowed back.
How quickly can we expect that abuser is going to be served?
It depends on how quickly they can be located, but as soon as they can be located. So the sheriff's office, oh sure,
the sheriff is going out there immediately.
They're required by the statute to make these cases a priority, and it's one of the unusual areas where the sheriff's office or the police entity is theoretically, at least, potentially liable if they don't pursue this with all vigor, because it was historically an area where sometimes even the police would tend to look the other way occasionally, thinking that this is just a spat. And the legislature said, well, if you do that now, if you willfully don't follow the rules and pursue this, then we're going to make you potentially liable civilly.
Sure. Jesse, you get calls from people who are on the receiving end of that sheriff summons, who just received the order of protection that they didn't know up until then was entered. What are the kinds of reactions that you hear from people, the concern from people, when in fact some of those may be unfounded allegations against someone?
Sure. It is an extreme remedy for somebody to be kicked out of their house, essentially. And Judge Diamond has explained, you kind of weigh the hardships. They favor the person that's seeking the order of protection, and so it's granted. But now you have a situation where an individual is now, that person doesn't have any place to live, perhaps can kind of go with family. And a lot of times I find that, these are a precursor to a divorce. And a lot of times what's happened is that, we'll get the order of protection, the client wants to do a divorce action, it'll be filed a lot of times before the date, because, and I'm pretty sure in DuPage, like in other places, like in Will, what they'll do is once you file a divorce action, the order of protection will be transferred to the presiding divorce judge, because he's going to handle all of the other issues.
Exactly. I think in its wisdom, the courts and the legislature have recognized that particularly when you have children involved, a single judge should have all of those issues in front of that judge. So you don't want one judge hearing one story and another one hearing a different story, and perhaps they're at cross purposes. That's not a good idea in the way to handle these. So typically, if I get a case in, that's one of the first things I'll ask is whether or not there is a divorce pending, because any return date under those circumstances will go back to the divorce court. And often, if there is a divorce pending, I will, we'll look at the divorce and determine whether or not. Sometimes it happens that there are unscrupulous parties that are trying to simply gain an advantage in the divorce, and therefore we'll take a look at that. And instead of granting the order, it's often the case that I will continue the case, require that notice be given to the spouse who's not there, and have the divorce court actually hear the order of protection, so that there is a fairness to both sides, because it is, as you say, it's an extreme order, and sometimes it's used as a sword instead of a shield.
Yeah.
Judge, if we can fast forward to the scenario where the sheriff has made service, they're coming before you on that return date that you've set for the hearing. Can you go through some of the different scenarios from it either being dropped, stay-away order, extension of the order? Can you talk about the different elements there?
Typically, when the cases come back onto my call, then I will call the cases up one at a time. I will ask initially whether or not the respondent, as he's referred to, the individual who's alleged to be the abuser, has been served with the paperwork. Very often the respondent has been served but does not appear. In any event, I will turn to the victim, assuming the victim is there, and very often they don't appear. But if the victim is there, I will ask if she wishes to proceed forward with the extension of the order of protection. At that point, the option is available to extend that order of protection, or that stay-away order, which is often a stay-away order, for up to 2 years. That's the maximum length of time.
Now, I wanted to ask you about that, Judge. 2 years sounds like an incredibly long period of time, because people are sometimes convicted of felonies, and they only have a stay-away order of 1 year. So 2 years on an order of protection that might not have had any legitimate or serious altercation about? It seems like a long period of time, does it not?
Well, at this stage of the proceedings, the parties have, the alleged abuser has the opportunity for the first time actually to be heard. So they can, in fact, they can actually be heard on 2 days' notice almost immediately. So if the sheriff goes out and serves the alleged abuser and he receives that, he may be kicked out of the house, he can go in right away and serve the alleged victim at an address which he's provided with to serve her, and then he can come back in within 2 days and say, I think this was based on lies. I want my hearing now, and then I would hear it immediately.
Typically, that person has counsel, correct?
That typically is the case. They'll go and get their lawyer.
And that'll be with the motion to vacate generally.
Right. Motion to vacate will be filed. But on the typical return date, let's say the 14-day date when they come in, I usually try and keep them on a 14-day leash simply because it is a rather extreme measure for the alleged abuser, and there's been no hearing yet for that person. So when they come back in, they're given the opportunity to have a hearing if they want. If they don't have an attorney yet and want an attorney, nobody has to proceed with an attorney. Attorneys are not provided. The public defender is not provided, regardless of indigency. But the alleged abuser can, we call him the respondent, can have an attorney if he wishes. If he says, I want an attorney, then I will give him time to get an attorney and will continue the status quo. In other words, the order of protection will stay in effect. If he wants to go to hearing, if he says, I object to this, sometimes they'll say, I don't have any problems staying away from her. I don't want to have anything to do with her anymore, but I want to see my child, or I want to get my clothes and my stereo and all my stuff out of the apartment. And in those cases, usually an agreed order can be reached where they can go back in the presence of a police officer and retrieve their items, or they can reach an agreement on visitation with the child. And we have a family center set up so that the alleged abuser and the victim never even have to see each other. One brings the child to the front door, the other picks up the child by coming in the back door, and so they never have to have contact again. So the stay away can be preserved, but the visitation with the children can take place. So that's another option.
Judge, the orders of protection are civil in nature.
Correct.
Right, and so the burden of proof then is
a preponderance of the evidence, basically a weighing of the scales, more weight on one side than the other. So you have to prove it's more probably true than not true that the allegations are in fact there to meet the requirements for the order of protection.
What about reciprocal orders of protection? I believe that the Act specifically prohibits an entry.
You can't, and sometimes you get what's called a race to the courthouse, where one party will come in and try and get an order of protection before the other one gets there, or maybe they've heard that this one's getting one and that one's not, for instance, and sometimes that even happens at the police stage where, the abuser may hit the victim, and I often see the case where then the abuser will quickly run to the phone and call the police and say, she hit me, and then the police work it out and one or the other winds up getting charged. But at any rate, you can't, once one party has an order of protection, the other party cannot get one. However, that doesn't mean I simply send the other party out of court if there is some claim that might have been legitimate but for the existence of the other order of protection. I will usually set that claim for the same return date. So in other words, if I gave an order of protection to the wife and I have her coming back in 14 days and then the husband comes in the next morning and says, no, it was really her, I may say, well, I'm not going to give you an order of protection, but I will set your case for hearing. I will deny it at this stage for an emergency, but I'll set it for hearing on the same day that your wife is coming back. And then it may be that the order actually flips over and that the husband wins the order of protection and the wife doesn't because maybe she wasn't truthful and he was. And sometimes that's the case.
Sure. I wanted to ask you a compound question, Judge. First of all, have you seen situations where the same petitioner is before you on numerous occasions? And then as a secondary to that, in a situation where someone has filed a false accusation, is there any kind of remedy that can be used against that person to prevent that, or any kind of sanction that could be awarded when someone blatantly files a false request for an order of protection?
Well, I always, as part of the process, I always swear people in. I'll answer your last question first. I always swear people in, so they're committing perjury. If I ask them a question, and I always ask them whether everything they put in their verified petition, which is, by the way, already verified by them signing it under oath, But once I put them under oath, I will ask them, is everything in this verified petition true? And then I may go through a series of questions about the petition. If something just doesn't seem right to me, I may ask them to try and get an idea of whether I think there might be something suspicious. Usually if I have a suspicion, those are the type of cases I will say, well, you're going to have to notify the other party and bring them in. Doesn't often happen, and I think people are, respectful enough of the courts and the process and understand the threat of perjury that hangs over them that they won't go out on a limb that far. So that's not usually a problem. However, there are sanctions available from a perjury charge to also sanctions involved in monetary sanctions if an attorney has to come in on the case, and sometimes we'll see those. But I don't find that's a real serious issue.
What about recidivism on the
recidivism? It's ironic, but I went to the National Judicial College out in Nevada, where we had a long course on this, and one of the things they taught us out at that course was that it takes about 7 times for the average abused victim to break away, to actually have the nerve to come into court and say, I'm done with this guy, I'm leaving. And so I often see them come in. But I frankly try and tell them, even when what's more commonly the case is they will come in and get the emergency order of protection, and then the reconciliation will take place. And so they'll come back in and say, Judge, I want to drop this order. I put them under oath. I ask them if they've been coerced or threatened in any manner. And sometimes I'll even, if the abuser is with them, I'll ask the alleged abuser, I'll ask him to stand out in the hall, and then I'll question her. But there's only so much you can do. I'm certainly not going to force her. I'm not going to make her be a victim again by trying to, force her to go through with this order of protection, because oftentimes, as I said, the abuser may be the only source of income for the household. The abuser may be the one who provides the only connection to society for this victim. But recidivism is fairly high, and oftentimes they'll come in. But even when they come in and say, I want to drop the order, I always try and remember to tell them, we're not going to count this against you. If you need this again, come back in, because we understand now, after the studies have been done, that this is frequently the case, and it's not a good idea to make the victim a second time.
You're actually witnessing firsthand a lot of the effects of the battered wife syndrome, where there's, requests for forgiveness, and then there's reprisals, and then it just cycles over and over again. So someone finally says, that's it, that's the last straw.
Exactly.
We even had, and we were talking actually a little bit before the show, I had a client that come in who was struck by her husband, told her to get an order of protection, was supposed to, didn't do it, came in to the office, and was struck by her husband that same day, and I told her, I said, got to get an order of protection, you got to stop that. Oh, didn't want to, and then, I said that, we could perhaps get a restraining order, which is, it achieves somewhat the same purpose as an order of protection, except it would be in the divorce court that would be entered, and in fact, if we step back for a second, we talk about the mutual order of protections. Sometimes I've resolved some of the order protections where we've entered a mutual restraining order for a certain period of time, and so so somebody's working, it doesn't go against them with respect to their job, because if you have certain jobs, that is continuous for you.
If you have an order of protection, the individual who the order of protection is against cannot possess a weapon. So that's for police officers and other people in the line of duty, security guards who need to use a weapon. That presents a problem. Now, there are situations where they have a certain, many of the jurisdictions now have a procedure where the weapon is just locked at the office. So in other words, when the police officer gets off duty, he surrenders his weapon. When he comes back on duty, he can get his weapon back, and that allows the breadwinner to continue to earn income for the family, so you're not punishing the family by taking the weapon away. But obviously, one of the phenomenon of this problem of domestic violence is that many homicides are directly related to domestic violence. The incidence of a homicide rises 14 to 15 times in the households where there's been a prior domestic violence action. So you will see that this is a process of escalation, where it starts at some level of abuse and then builds up to eventually get to a physical level and can turn lethal. So the idea is if you prosecute people who are committing domestic violence and you hold them accountable you can reduce domestic violence in your community by about 50%. So the benefits of this law have already been seen. And very often if you get the abuser into the system and they're charged, for instance, with a crime of domestic violence, and they're sent to the program that we have, and there's a special program sent up that will send these abusers through the program, the recidivism rate then is very low. They have a success rate of about 70%. In other words, about 70% of the people who actually make it through the program in domestic violence, I believe that's the statistic, you don't see them on more domestic violence cases down the road. So and the irony of this system is that it's cyclical. Generation to generation seems to pass it on. When we were at the National Judicial College, one of the judges from out in California told us about how in his courtroom they have a 911 tape that a lot of the people in this field will listen to, and it's of a 5-year-old boy. And as he's speaking on the phone to the 911 operator, there is this fight going on in the background with the husband going after the wife, and he's screaming, and you can hear him hitting her. And it actually goes on for about 15 minutes. But this judge talked about how he would play this tape, he would make the abuser listen to this tape, and he'd get off the bench, and after about 10 minutes he'd come back and he'd say the abuser was always crying. And it wasn't because he recognized himself as a husband in the background hitting the wife. He recognized himself as the 5-year-old who was the one who was witnessing this of his parents. So that's the cyclical nature of this, and if you can break that cycle, if you can get these abusers into the program, very often you can end the abuse at that stage. And that's why it becomes so important to utilize these tools, such as the order of protection, to cure these problems.
Well, and speaking of that, what happens if you issue the order of protection and the respondent is served, and then he violates the order of protection?
He's arrested. It's a crime. And it's a crime. It's a Class A misdemeanor. It's punished just as though it was domestic violence. And that's often the case. We often get these people who are arrested for the violations, and they are forced through the system, into these programs if we can get it through the program.
Now, does that stay in your courtroom, or does that go to a separate courtroom for the criminal proceedings?
Yeah, the criminal proceedings go to a separate courtroom. I often cover cases from that if the judge there is on vacation, so I have some familiarity with that. But that's again, there's a separate call for domestic violence cases, so these are handled by a separate judge who has some experience in those matters as well.
So if there was a previous order of protection, then that whole matter then would be transferred to the domestic violence judge?
The order of protection would stay with me on the criminal side of things, but the violation of the order of protection would go as a criminal charge to that judge, and just as any domestic battery would go to that judge.
Well, it's a shame we live in a society where we have to have courts that protect people, and people can't keep their hands to themselves, but it's good to know that at least we have this as an option when someone needs the protection, that they can come before you and get an order and get some peace of mind for up to 2 years. And we really appreciate you joining us today, Judge.
Well, thank you very much for having me. I think it's a very important law, and I hope that the word gets out to the community that it is available. We have it online now. People will soon be able to go to their local township offices or to their libraries. They'll be able to do it on their own computer by going to the clerk's site and filing the petition, and then coming into court after they fill it all out.
Thank you very much.
Okay.
Thank you.
You're welcome.
Thank you. You watched Orders of Protection on Legal Action. For Jesse Barrientos, my name is Dave Siegel. We'll see you next time.